able to be with us today. As you know, we have a very full agenda in front of us. So I'll call the meeting to order. State Government, Finance and Policy and Elections Committee, today being Tuesday, April 6, 2021. And on our agenda today, we're going to take action on four bills actually, all of which have been previously heard. So the policy and the discussion and all of those are previously heard. We want to move them out either to another committee or to general orders. And so the first one I will move is Senate File 1861, and the chief author is Senator Abeler, and the subject is Autism Awareness and Acceptance Day Establishment. So I will move that Senate File 1861 be recommended to pass and placed on general orders. On that motion, please unmute and be on video, on camera. All those in favor say aye and raise your hand.
Aye.
Aye.
Opposed? Motion prevails. Senate File 1861 is on its way to general orders. The next one is Senate File 1520, Senator Rest's bill, also on Autism Awareness and Acceptance Day. I will move Senate File 1520 be recommended to pass and placed on general orders. All those in favor, please say aye and raise your hand.
Aye.
Aye.
Opposed? Motion prevails. Senate File 1520 is on its way to general orders. The next bill is Senate File 799, Senator Fateh's bill, and that is again on Autism Awareness and Acceptance Day, previously heard on the subject. Thank you, Senator Fateh. And so I will move, Senator Fateh, would you like to move your bill? Be recommended, you have to unmute.
Yes. Yes, thank you so much, Senator or Madam Chair. I'll move the bill to be added or included.
Okay. Senator Fateh moves that Senate File 799 be recommended to pass and placed on general orders. All those in favor say aye and raise your hand.
Aye.
Aye.
All those opposed, motion prevails. Senator Fateh, Senate File 799 is on its way to general orders. Thank you. So next bill we will go to, again, has been previously heard, and Senator Howe, I'll hand the gavel to you for this bill.
Thank you, Madam Chair. Senator Kiffmeyer, Senate File 2279. Senator Kiffmeyer, you want to move your bill?
Yes, I do. Thank you very much. And members, you've previously heard this bill, so I'll move that Senate File 2279 be recommended to pass and referred to the Civil Law and Data Practices Committee.
All those in favor, please unmute, raise your hand and say aye.
Aye.
Those opposed,
Aye.
nay. With that, the Senate File 2279 is on its way to Civil Law and Data Practices Committee. Next file is Senate File 1831. Senator Kiffmeyer, you want to introduce your bill, and I take it we'll have someone run through the bill, but would you like to introduce it at first?
Yeah, Mr. Chair, I will move Senate File 1831, and this bill originally was Legislative Reference Library Document Deposit Cost Provision. That's all, a clarification. It's a vehicle bill, as is customarily done. Representative Nelson has a companion in the House, and so that we match up for our state government budget bills. And so that's the core of it, but I will also, we have the A2 amendment, and that is what we will be working off of today. And yes, Mr. Chair, I would like to have the staff go through the bill for us, which members will take a bit of time to go through this bill.
Thank you, Senator Kiffmeyer. Which will go first? Will Ms. James or, Mr. Erickson, you'll go first. All right, Mr. Erickson, please tell us which document we're going to look at and take us through the bill.
Yes, thank you, Mr. Chair. Let me quick share my screen. Is that coming through okay?
Yes.
Great. Okay, so there's two spreadsheets that have been shared with the committee and that are also $16,000 one time for the Secretary of State. The bill adopts the governor's provision relating to the Safe at Home program, expanding the operations of that program somewhat as demand within the program has increased. There is also $50,000 to comply with a change in the bill that modifies how business addresses are displayed on the website, and Ms. James will discuss that provision. There is $919,000 one time to implement generally the provisions relating to elections in Article 4, which Ms. Stengel will describe in much greater detail. There is $9.75 million each year for election equipment grants, which is decreased to $5.5 million each year in the tails. The bill does not adopt the governor's position on additional HAVA funding that has become available. However, there is a modification to existing HAVA appropriations in the bill, requiring that any unobligated balances from the 2018 or 2020 tranches of HAVA that are currently unobligated be spent for the purposes of election equipment grants. Moving to Minute, there is a operating adjustment. I'll actually skip to the second line here. An operating adjustment that decreases their fiscal 21 appropriation by $379,000. This is the first of several adjustments that the governor identified in the last fiscal year as by impounding a certain amount of their operating money and holding it back and canceling it in his own budget. This bill generally also adopts those recommendations and then carries forward the operating adjustment into the budget biennium and then into the tails biennium. There's also the bill also adopts the Blue Ribbon Council recommendations that the governor recommended. However, instead of funding it as a general fund appropriation, this is a rider to the existing cybersecurity enhancements money that was made available beginning in the 2019 budget bill. At the Department of Administration, this bill funds the in lieu of rent increase that the Department of Admin has asked for. There is again the operating adjustment that cancels the administrative holdback from fiscal 21 and carries it forward. There is $10,000 each year, one time, for flags and flagpoles for SHPO, which Ms. James will discuss in her portion. There is a $5.5 million appropriation for the sale of the 1415 Lorient Street building. This is to reimburse FEMA for the costs for which admin had originally been reimbursed for the building. There's also $56,000 in allowed expenses related to making the building saleable. This is a statutory appropriation. There's also a $174,000 one-time appropriation to repair and reinstall the statue of Christopher Columbus on the Capitol complex. At MMB, there is, again, the operating adjustment that adopts the governor's cancellation of administrative holdbacks and then carries that operating adjustment forward into the current and tails biennia. There is an instruction to MMB to reduce their executive budget officer staff by 6 FTEs. There is an adoption of the governor's proposal to transfer single audit responsibilities from the Office of the Legislative Auditor to MMB. However, this bill, as you will have noted up in the legislative section, does not have a reduction to the OLA that the governor used to pay for that proposal. Excuse me, I lost my place. And then finally, there's the first of several lines that will be related to the Payment Plus program that is authorized in the A2 amendment. This portion is for MMB to use a portion of the money from the Payment Plus program to administer the program. In general, the program sets up a program by which vendors can receive electronic rebates to increase the speed with which they are paid back. And then the state will keep a portion of that money in the general fund. We'll see that below. The Department of Revenue has, again, the same operating cancellation in fiscal 21 that is carried forward into the current tails biennia. The Historical Society has a one-time $250,000 appropriation for a pass-through grant to Farm America. This was a Senator Weber bill. The Minnesota Arts Board has an $86,000 one-time cancellation in fiscal 21. This is from funds that had been previously authorized for them to move their headquarters. The bill also shifts $10 million from state aid to the Minneapolis Employee Retirement Fund and shifts the burdens to employers. So the para still receives a total of $37 million, excuse me, but it is shifted somewhat from the state's responsibility to the employer's responsibility. The Gambling Control Board has 2 change items to increase their staff and then also to create and maintain an information system. This is the full ask made by the Gambling Control Board in the governor's original and revised recommendations. Moving down to revenues and other transfers, there is an a capturing of savings that result from a provision in the bill that reduces agency appropriations for FTEs that are unfilled after 180 days, which amounts to $274,000 annually in general fund savings. There's also the deposit of money relating to the sale of the 1415 Lorient Street building. This, of course, would be then paid to FEMA, but this is the other half of that change item. Here is the Payment Plus general fund deposit. The Department of Management and Budget expects there to be a little bit over $1 million placed into the general fund as a result of implementing this program. There is also $179,000 canceled out of the Information and Telecommunications account, also known as the Odyssey Fund, for projects, IT-based projects that agencies are able to use certain operating money for. These are projects that have already been completed and the money is no longer needed. If you go down to lines 176 and 177, there's a couple of other cancellations not out of the general fund, but for the same purposes. And then finally, here is the non-general fund revenue, the last component of that Payment Plus program that is offsetting the expenditures that MMB is allowed to make to administer the program. And then, Mr. Chair, that actually brings us to the end, and this reconciliation at the bottom just pulls us to the $23.4 million negative target that the State Government Committee was given.
Thank you, Mr. Erickson. Well done. Now we'll go to Ms. James to take us through the A2 amendment.
Mr. Chair and members, I will be begin on page 15 with Article 2. Section 1 of Article 2 specifies that documents received by the Legislative Reference Library are to be received without cost to the legislature or the Legislative Reference Library. Section 2 makes the Legislative Coordinating Commission responsible with respect to the joint legislative commissions, committees, offices, and task force. It just sort of reflects the current role that the LCC plays. Section 3 establishes the Legislative Commission on Cybersecurity. Section 4, which is as at the top of page 17, is the beginning of several sections from the Office of the Legislative Auditor. Section 4 precludes an employee of the Legislative Auditor from running for elected office. It makes other changes to reflect how the office is staffed and how it is organized. Section 5 authorizes the Legislative Auditor to conduct certain types of special reviews. Section 6 on page 18 modifies requirements for the OLA to conduct audits of financial activities, and it makes the requirement subject to availability of resources. It also clarifies those entities for which the OLA must conduct the audits, and it eliminates the requirement that the OLA visit each agency in person without notice once a year. Section 7 on page 19 of the bill modifies requirements on the OLA to perform audits of the Department of Human Services. It also makes the requirement subject to availability of resources, and it modifies the description of the work that the OLA is to perform. Section 8 appropriates eliminates a requirement for the auditor to audit reports and subscribers of bulk data from driver and vehicle services. This relates to data practices. And the money that's appropriated is in the data security account. Section 9 clarifies that public officials must provide information to the OLA at the OLA's request. And it also changes the requirement that an official aid the OLA. It changes it from a requirement to aid them to a requirement to cooperate with them. Section 10 has some clarifying changes regarding audit data. Then Section 11 is unrelated to the OLA. We're done with the OLA for the moment. This section authorizes the Legislative Budget Office to prepare fiscal notes when an agency does not do so. Under current law, it's the agencies who prepare the notes and the Legislative Budget Office, the LBO, that coordinates them. And this would authorize the LBO to prepare the fiscal notes. Section 12 precludes the Secretary of State from displaying the address of a business that's made a request to have its address omitted from its website. Only certain types of businesses are eligible for this. Section 13 on page 22 is from Senator Osmick's bill, Senate File 4. It requires legislative approval for the governor to extend a peacetime emergency beyond 30 days. Section 14 on page 23 requires an agency to have specific authority to adopt rules. Also on page 23 is section 15. This lowers the threshold for the number of people needed to request a hearing for rulemaking. This is when rulemaking is noticed as, it has a dual notice, meaning there won't be a hearing unless enough people request a hearing. And this changes the threshold for that from 100 people down to 25 people. Page 24, section 16 is from Senator Newman's bill. This makes a decision of the administrative law judge the final decision in a contested case hearing. Section 17, also on page 24, is the first of many sections of the bill from Senate File 353, authored by Senator Curran. This is the minute bill. These sections, which I'm not going to detail at all here unless anyone has questions, makes Minute a department of the state. It also reduces, it clarifies their role throughout their statutes. It eliminates some things that Minute hasn't been doing or it hasn't made sense for Minute to do related to local governments. It also creates a commission that will mirror the Blue Ribbon Commission that on IT that the governor had this summer, that has private entities serving in that on that commission. Those are the major features of the provisions from Senate File 353. Section 18 on page 25 is from Senator Tomassoni's bill. It requires that layoffs of state employees be made in a geographically balanced manner. Section 19 on page 25 is from Senator Senjum's bill to reestablish the SAVI program. SAVI is the State Agency Value Initiative Program. And through this program, agencies can, if they save money through efficiencies, are able to hang on to the money and use it in the next biennium for certain purposes. Section 20 on page 26 limits, this is from Senator Cran's bill, Senate File 299. It limits the growth in state employment based on population growth. Section 21 is from Senator Kiffmeyer's bill, which was actually the governor's bill, Senate File 974. This particular section is authorizes MMB to contract with an auditor to perform the single audit, and Mr. Erickson described this in quite a bit of detail. Section 22, the next section, is from Senator Kiffmeyer's bill 1835. It deletes an obsolete fund from the list of allowed uses of forecasted general fund positive balance. On page 28, section 23 is a conforming change relating to the SAVI program. Section 24 is the second of the two provisions that are included from the governor's bill, Senate File 974, authored by Senator Kiffmeyer. This section authorizes MMB to issue virtual payments, and it provides for that vendor rebate program that Mr. Erickson described. Section 25 on page 28 modifies the list of buildings that the Department of Administration is responsible to operate. Page 29, section 26, this is from Senator Johnson's bill 948. It requires the Department of Administration to charge users of electric cars for charging stations on the Capitol complex. Section 27 is the first of several sections that give SHPO, the State Historic Preservation Office, expanded responsibilities with respect to the state's historic sites and places. Specifically, Section 27 requires that SHPO be given notice that a historic place or site has been determined to be declared surplus. So that'd be a requirement on the Department of Administration. Section 28 precludes disposal of a historic site or place without specific authorization in law. Section 29 authorizes the Commissioner of Administration to convey state service dogs to their handlers. This is modified a little bit from the last time the committee saw it to be clear that the canines that can be conveyed are those that are retired from state service. Section 30 eliminates two obsolete uses for the General Services Revolving Fund. Section 31 on page 31 defines passenger motor vehicles for purposes of the Commissioner of Administration's motor pool statute. Section 32 adds an allowed use for motor pools for the Department of Corrections. Section 33 on page 32. These are the sections from the minute bill, section 33 through 45 and 47. And as I mentioned, these include technical and clarifying changes to the role that Minute plays, eliminates some duties that are related to the local governments, and it modifies that advisory council to mirror the Blue Ribbon panel on IT. And that takes us to page 43 and section 46, which is from Senator Benson's bill 2178. This requires MMB to conduct a reverse auction to select a pharmacy benefit manager to provide drug benefits for CGIP, the State Employee Group Insurance Plan. Which takes us to page 47. Section 47, also on page 47, which is from Senate File 353, the minute bill. This is a technical change in this section. Similarly, the next section, Section 48, it's from Senate File 1879. It's also a technical change. And I will note that this provision also has changed from the last time the committee saw this section in committee. On line 47.28, the last time the committee saw this proposal, it provided for a switch in responsibility here to the Historical Society to be the entity that is designated as the state agency with power to accept money available to the state by the federal government. But this has been changed to stay with current law, where it is the Department of Administration that has that role and responsibility. Page 48, Section 49. This designates the Commissioner of Administration as the State Preservation Officer for the purposes of the Federal National Historic Preservation Act. A few years ago, when the responsibilities for preservation were moved from, when SHPO was moved from being under the Historical Society to the Department of Administration, this is a provision that probably should have been changed at that time. So this is correcting that. And also makes a technical change. Section 50 on page 48 corrects a cross-reference to federal law, and also has a change from the, I'm sorry, this is the section that has the change from the Department of Administration, or it has a change from the last time you saw it. So the last time you saw this on page 48, line 14, the Department of Administration had been changed to the Historical Society. But this keeps it with current law, where the Department of Administration is designated as the state agency for purposes of the federal act that provides for preservation of historical and archaeological data. Section 51 is a definition of the State Historic Preservation Office, which hadn't existed in statute before. Section 52 specifies that SHPO, along with the Historical Society, has to share duties to administer and enforce historic preservation statutes. It's really a conforming change related to other changes that are made in the bill. On page 49, Section 53 adds SHPO to the entities to whom the state archaeologist must provide certain information and reports. Section 54 on page 49 adds SHPO to the list of entities that agencies must cooperate with in designating and preserving historic places and sites. It also changes the entity to whom violations of preservation statutes are reported from the Historical Society to the archaeologist. It changes the entity to whom construction and development plans must be submitted for projects on significant archaeological or historic sites. Changes it from the Historical Society to SHPO. Section 55 on page 50 limits the Historical Society's responsibility for controlling historic sites to those sites that are owned by the Historical Society. Section 56 gives SHPO responsibility for historic sites owned by the state. On page 51, Section 57 requires an agency to consult with SHPO before conveying state-owned historic places or sites. On page 52, Section 58 adds SHPO to the list of entities that agencies must cooperate with in safeguarding and preserving state historic sites and archaeological properties. Section 59 makes SHPO responsible, like the Historical Society is, to notify the legislature of a need for changes to the list of properties designated as historic sites. It also makes SHPO, instead of the Historical Society, responsible for documentation and for providing an opinion on whether a property meets criteria to be on the State Register of Historic Places. Section 60 is a chair's initiative. This requires that U.S. and Minnesota flags be flown at state historic sites. It has an effective date in 2024, but provides that SHPO begin installing the flags as soon as resources are available for this purpose. Section 61 is a chair's initiative. It makes SHPO, instead of the Historical Society, responsible for contracting with local governments for operations of historic sites. Currently, that's the Historical Society who performs that function. On page 53, section 62 is a technical change. Section 63 is the beginning of several sections scattered, they're not all in sequence, that move the regulation of practices that are currently regulated by the Board of Cosmetology to the Board of Health. So those are sections 63, 65, 67, 82, 83, and part of a repealer. Section 64 is Senator Housley's bill, Senate File 1413. This eliminates the requirement that a school manager be a licensed cosmetologist. And I'm going to skip the sections that relate to moving the cosmetology into the Department of Health. Section 66 precludes a public employer from contracting to pay more in compensation than is permitted under an approved spending plan. Section 68 deals with the star rating system implemented and administered by the Gambling Control Board. This changes the way that the calculations are made and the thresholds for what the stars reflect. And the star rating system is a mechanism for evaluating how a charitable organization is making use of the proceeds from lawful gambling. Section 69 on page 56 allows a member of the Gambling Control Board to continue to serve as a member until a successor is appointed, unless the appointing authority for that member objects. Section 70 on page 56 keeps the name of a lottery winner private. On page 57, section 71 and 72 work together. Mr. Erickson mentioned this shifts $10 million per year payment to PARA, the Public Employee Retirement Plan, to pay for MRF, the MRF consolidation from many years ago, which MRF is the Minneapolis Employers Retirement Fund. This shifts $10 million a year currently being made by the state. It shifts that $10 million to those employers. Page 58, section 73. This is a chair's initiative. This relates to local impact notes. Because the LBO has the responsibility now, instead of MMB, to prepare local impact notes, this statutory transfer of money that had been going to MMB for the cost of preparing local impact notes is now moved to the LBO. On page 59, section 74 puts the state on daylight savings time year-round once federal law permits us to do that. Section 75 is Senator Rosen's bill, Senate File 8. This requires an appropriation by law to spend federal funds that are received by the state for COVID-19 between the effective date of the act and June 30th, 2022. Section 76 on page 59 is Senator Abler's bill that provides that a violation of an executive order during the peacetime emergency, there can be additional consequences meted out by an agency beyond those specified in the executive order. Page 60, section 77 is Senator Kiffmeyer's bill, Senate File 411. This reduces appropriations to agencies for operations to reflect salaries for unfilled positions that go unfilled for 180 days after posting. This provision is also slightly different than the last time the committee saw it. Paragraph or clause 1 is a newly added exception or category of positions that are exempted from this section. And this is in response to concerns raised in the fiscal note about lack of clarity about positions that this applied to. Section 78 is an obsolete rules report. This is from Senate Senator Utke's bill. This requires that this year's obsolete rules report also describe current grants of rulemaking authority for each agency. On page 61, section 79 is another provision from the minute bill. This sets up the first meetings and the first appointments for the new Legislative Commission on Cybersecurity. Senate file, or section 80 is from Senate file 1836 of Senator Kiffmeyer's. This requires the Commissioner of Administration to sell the property in St. Paul that was acquired using COVID funds, the L'Orient Street property. Section 81 requires that the Commissioner of Administration repair and return the Columbus statute to its place on the Capitol grounds with the same signage as it has now. Section 82 is part of the cosmetologist move. Section 83 is a series of revisor instructions that relate to other things that we've talked about in the bill. Section 84 is a repealer. There are three kind of categories of repealers here. The first one is related to the OLA, and this is repealing audits for programs and services in the Departments of Transportation and Public Safety. The second category are a series of repeals for minute. And the third category relate to the shift from the Board of Cosmetology to the Board of Health for regulating the practices of cosmetology. And that is the bill.
Well, thank you, Ms. James. I see there's, all right, is there any more that we need to go through, or is that the entire bill? Is it?
Mr. Chair, there are two more articles, and
I thought so. So I think Ms. Stangel's going to take us through those articles.
That's correct, Mr. Chair.
Ms. Stangel.
Thank you, Mr. Chair and members. I'll cover Articles 3 and 4. Article 3 has to do with campaign finance, and this is comprised essentially of three bills that were before the committee. Section 1 is Senator Curran's bill that allows a candidate to make a non-campaign disbursement for up to $2,000 over a 2-year period for security expenses. And the remainder of the bill, with one exception, are all the campaign finance board provisions that made a variety of changes to time and place for filing, changes to economic interest statements, sort of aligning the timeline, and a variety of other changes that I won't go into detail. They are the same as they appeared before the committee before. The only other section that was not a campaign finance bill provision is Section 12, and that's Senator Osmic's provision relating to public subsidies when the candidate's opponent is not eligible for the subsidy. So with that, I'll start on Article 4. This includes a variety of provisions that were before the committee. Some have been amended, some have not, and I'll try to flag those as we go through. And there are some chair's initiatives here that have not yet been before the committee. So I think it might help to go over two of the big concepts a little bit beforehand so I can sort of shorthand it as we go through section by section. One of the chair's initiatives is the insertion of Senate File 179, which was Senator Kiffmeyer's bill, and this has to do with changing Election Day registration provisions. So under this, under the sections that we'll go through that relate to the Election Day registration, any person that registers to vote on Election Day will cast a provisional ballot instead of the current process. And the idea is that the voter registration application will be processed within the week after the election, and that application has to be processed before the ballot can be accepted or not. The person that cast that ballot isn't required to show up in the office again. It's an administrative process that they follow, similar to how they would process voter registration applications prior to Election Day. If the person is registered, their ballot is accepted. If they're not registered, their ballot is rejected. So I think with that sort of explanation, I'll go through section by section. Section 1 on page 74 and section 2 on 75 are Senator Newman's prohibitions on the use of public funds for ballot question advocacy. Section 3 on page 75 is an Election Day registration section. And this has to do when an incomplete registration is submitted by mail, It outlines what the county auditor has to do, which is basically tell the person they need to submit a proper registration in one of the acceptable ways. So online, in person, those sorts of things. Section 4 is another election day registration provision. This amends the current process for election day voter registration. And as described before, it gets rid of the current process for proving residency and those sorts of things and replaces it by completing a voter registration application. It also eliminates vouching, which is relevant to Section 5 because that strikes some language related to vouching. Section 6 is from Senator Kiffmeyer's challenged voter provisions. And as you remember, that was before the committee. And that's when a challenged voter has to submit a challenged ballot, which is similar to a provisional ballot. Here, Section 6 has to do with the public voter information list. And this the public information voter list has to include information about challenges, challenge statuses for voters and the changes over time to those statuses. Section 7 is a new section. It's another election day registration provision. This requires election day voter registration applications to be entered into the statewide voter registration and processed within 7 days after the election. And this is done with the same sort of checks with the state databases that are done for applications received prior to election day. Section 8 is an OSS provision about post-election sampling reports needing to be done every year. Section 9 is a challenged voter provision that requires, and this is a bit of a change from before, it requires all changes in status based on state data. So that's things by like the courts, corrections, or other state agencies to be notified of that change in status. And then there's a chance to contest that before the agency if the person believes the challenge was not accurate. One of the changes here is that there were some additional state agencies added to this, one of which is has to do with name changes in the courts or death records. Section 10 is another election day registration provision. This requires an electronic roster to be able to print voter registration applications that can be attached to the provisional ballot envelope. Section 11 is an election day registration provision, and this has to do with how registrations are processed within the week after the election. Section 12 is an OSS agency bill provision that allows people at the military academies to cast absentee ballots under the UOCAVA provisions. Section 13 is another OSS provision that has to do with absentee ballot voters, their names being public in the same manner as other public information. Section 14 on page 86 is another election day registration provision. This amends the process to register to vote when you are submitting an absentee ballot, and it describes the process for where that voter registration application has to be included in the envelopes. And again, similar to same-day registration, some of the oath provisions are changed because you don't prove residency in the same manner anymore. That's all done through the voter registration application. Section 15 makes a similar change on the absentee ballot witness portion of the envelope. Section 17 on page 87 has to do with what county auditors now have to do when they open an absentee ballot return envelope. They have to look to see if there's a voter registration application, and if so, they take it out and process it immediately. Section 17 on page 88 comes from a Senator Kiffmeyer bill that requires a county auditor to designate in-person absentee polling places as part of the regular annual process. Polling places have to be open for the entire absentee voting period. One change from the last time this was before the committee is now before all locations had to be open at the same hours and times as the county office. Now it's the county or the city office, depending on who's administering the absentee ballots. Section 18 is an OSS provision, and it strikes a reference to setting polling places that is taken over by Section 17. Section 19 is an election day registration provision and allows only pre-registered voters to place absentee ballots into the ballot box in counties that allow for that in the week before the election. Section 20 is another OSS provision that has to do with the names of absentee ballots that have not been accepted being available to the public. Section 21 is an election day registration provision. And there are some corrections from the OSS bill that correct terminology to refer to the proper type of envelope. The EDR portion of this is that when the ballot board is looking at an absentee ballot, they have to make sure that the person is registered to vote before their ballot is accepted. Section 22 corrects terminology to reflect the proper type of absentee ballot. Section 23 corrects terminology again. Section 24 on page 92 has to do from the OSS bill, requires candidates that filed jointly have to jointly make requests to have their write-in votes counted. Section 25 and Section 26 on page 93 and 94 are new provisions that haven't been before the committee. They allow municipalities to redesignate polling places after redistricting is complete outside of the usual process. And the usual process means they have to be done by December 31st. This allows them to change them in the spring after redistricting is completed. Section 27 is another Senator Kiffmeyer provision that has to do with the election judge party affiliation list going to the political parties. Section 28 is an OSS provision requiring special elections to include a write-in line. Section 29 is Senator Curran's ranked choice voting prohibition. Section 30 on page 96 is an OSS provision requiring the town clerk to notify the Secretary of State if voting hours will start later than otherwise required. Section 31 is another OSS provision that does the same thing as the previous section, only for unorganized territory. Section 32 is a challenge voter provision. And this section requires the judge to confirm information about the voter before they can sign the roster. A voter whose registration status is challenged has to cast either an administratively challenged ballot or a verification challenged ballot. And this is a little bit different than when it appeared before the committee previously. An administrative challenged ballot is for challenges based on state data. So those are, again, the things like from corrections or the courts or DPS. And anybody that has any other type of challenge not based on state data cast a verification challenged ballot. And I'll get into the distinction between those two in a few minutes. Section 33 eliminates the oath that a person takes to overcome a challenge in the polling place. And that's consistent because all challenged voters are required to cast a challenged ballot and are not allowed to cast a regular ballot. Section 34 is a election day registration provision, and this is the provision for casting provisional ballots. As previously indicated, everyone that registers on election day will now cast a provisional ballot. It's similar to an absentee ballot in that there's a series of envelopes. The ballot is filled out and put into the envelopes, and then they're set aside together. Afterwards, election judges of different political parties process all of these voter registration applications and then accept or reject the ballot based on whether the voter is or is not registered. There are provisions for reconciliation, opening, and counting the ballots as well. Section 35 on page 101 has to do with the challenged ballots. And again, a challenged ballot is similar to an absentee ballot with a series of envelopes, and then they're set aside and processed later. So as I mentioned before, there are two types of challenged ballots. One is the administrative challenged ballots, and those are the ones that are based on state data. So those do not require the person to show up to prove their eligibility to vote. Instead, the election judges of different political parties will review the SVRS data to determine whether the person was challenged on election day or not. If they were not challenged, the ballot is accepted. If they were challenged on election day, the ballot is rejected. The other type of ballot is the verification challenged ballot, and those are anybody that doesn't have a challenge based on state data. In that case, the person does have to appear before election judges in the county or city auditor or clerk's office within a week after the election to prove that they're eligible to vote and overcome that challenge. Again, there are provisions for reconciling, opening, and counting those ballots. Section 36 is a new provision. It relates to provisional and challenged ballots, and it requires the list of voters who voted, cast those ballots, and had their ballots rejected made public after the election. Section 37 on 104 allows the election judges to presume total counts provided in prepackaged ballots is correct when counting ballots after the election. Section 38 is a new section, and this requires an election judge to provide a copy of the summary statement or the tape results to a candidate at the polling place after the polls close. Section 39 requires, and this is an OSS provision, it requires the election judges to deliver one set of summary statements instead of two. As previously mentioned, the provisional ballot and challenge ballots have processing for a week after, so that means that the canvassing timelines have to change. Sections 40 and 41 are the first of a series of adjustments to canvassing timelines, pushing everything back by a week. Section 42 on page 107 specifies it's an OSS provision about when a recount may be filed. Section 43 on 109 is an election day registration provision that provides has to do with the county canvassing report. If it's not received by a certain timeline, they have to resubmit it. Section 44 on 109 is an OSS provision about when there is a vacant office, a vacant office filling the remainder of a term on the same ballot as the regular term. And Section 45 has to do with that same situation. Section 46 on 110 is an OSS provision that prohibits special elections on a holiday or shortly before or after that holiday. Section 47 is an OSS provision that's on page 110 that has to do with the contest period for a special election. Section 48 and 49 are OSS provisions and have to do with when both U.S. Senate offices are on the ballot at the same time. Sections 50 through 53 on 111 through 113 are all adjustments to the canvassing timeline. Section 54 is an OSS provision that strikes a cross-reference to a repealed subdivision. Section 55 on 114 is from the OSS bill, as is Section 56, and these modify the thresholds for determining acceptable performance by a voting system and the threshold for when additional review is necessary. Section 57 is an OSS provision having to do with ballot titles when school and municipal elections are at the same time. Section 58 on 116 is a new section that's a chair's initiative, and this requires all ballot tabulators to maintain audit logs. And it provides a definition of audit logs. Basically, it's tracking everything that machine does in a way that can be looked at later. County auditors and municipal clerks have to maintain these with the rest of the, print them out and maintain them with the rest of the election materials. And they also provide them to the Secretary of State, who will then bundle them up and provide them to the legislature. And when I'm talking about them, I mean the printouts of the logs, not the equipment itself. Section 59 on 117 is an OSS provision, is Section 60 that have to do some cleanup with the presidential nomination primary about the data classifications and making it apply only to participating parties. Section 61 and 62 on page 118 are changes to the canvassing timeline. Section 63 has to do with taking the oath within 10 days after winning a special town election. That's an OSS provision. Section 64 on 119 is an OSS provision, and it provides a cross-reference in the city chapter saying election laws do apply to city council elections. Section 65 is a new provision that's a chair's initiative, and this requires the OLA to conduct an audit of election equipment and related software. It includes looking at policies and practices for selecting, buying, and maintaining the software, as well as an examination of the equipment used in the 2020 election. There's some specific requirements to look at machines that connect to the internet and how that is done. The auditor may or may not contract for all or part of this as that office sees fit. Section 66 is a election day registration provision that requires the Secretary of State to contract with a vendor to conduct a public awareness campaign to encourage people to vote encourage people to register prior to election day. Section 67 is a repealer, and it repeals several provisions relating to election day registration that are replaced with provisions already in the bill. And Section 68 is the effective date. In general, things are effective July 1st of this year, with the exception of the provisions relating to challenged voters that goes into effect on January 1st, 2022. And that concludes the overview, Mr. Chair.
Thank you, Ms. Stengel. Very well done. I just want to remind testifiers, we're going to go to testifiers now. Just remind testifiers that we got a hard stop because we have session. So please keep in mind that be brief and be concise. Try to adhere to that 3.5 minutes. And we'll first start with Commissioner Robert Davis from the Department of Admin. Ms. Roberts Davis.
Good morning, Mr. Chair and committee members. Can you hear me okay?
Yes, very well.
Thank you. For the record, I'm Alice Roberts Davis, Commissioner of the Department of Administration, and I will try to adhere to the 3.5 minutes. Thank you for including several provisions necessary to the Department of Administration's operations, in particular, the needed increase to the in lieu of rent funding. As you know, this is the only source of funding for operations and maintenance of the public, legislative, and ceremonial spaces on the Capitol complex, so that is greatly appreciated. I also appreciate the number of technical changes included that are needed to update the department's statutes and better reflect the services admin provides to our partners, so thank you for that as well. However, there are also some difficulties with the bill. The budget cuts and the delete everything amendment would make it impossible for the department to deliver its statutorily mandated services. The permanent $300,000 general fund cut is not only unsustainable, but is coupled with provisions that apparently require the department to assume operations of nearly half of the state's historic sites. The reduction in fiscal year 2021 represents costs avoided due to the hiring freeze and does not allow admin to provide the level of services that Minnesotans expect. In contrast, Governor Walz's budget recommendations for the Department of Administration ensure that essential operations like the previously mentioned in lieu of rent and Capitol complex parking operations can be maintained. Additionally, the governor's budget invests in strategic planning for state facilities consistent with 21st century service delivery and workforce expectations, as well as investments to promote greater equity in public procurement and grants administration. I appreciate that the committee has included the technical changes related to the 2018 move of the State Historic Preservation Office to the Department of Administration. However, there are several provisions related to the SHPO and the Delete Everything Amendment that are beyond the scope and expertise of our staff. The SHPO primarily serves a regulatory function, and this proposal appears to have the office assuming the management of nearly half of the state's historic sites. We are not aware of why this transfer is even under consideration, and these responsibilities are outside of the scope of SHPO's expertise and its federally and state mandated duties. There's also no funding included with this major shift of control. Within those provisions is a provision that requires a notice to SHPO if there's an historic property going through the surplus disposition process. And current law 138.655 subdivision 2 already includes review and consultation with SHPO to avoid the transfer of a designated historic property outside of state ownership. So in short, current law and current practice already require consultation. Shifting gears slightly as it relates to census data, I'd like to make another pitch to modify the date that population counts are due to local governments this year. Normally, we would be getting information now to be disseminated to local governments by June 1st. However, we will not receive this information until at least the end of August from the federal government. There's no way for us to make this statutory deadline. So to mitigate this issue in the future, we suggest updating this deadline to 6 weeks after the information is received from the federal government. In 2019, the Office of Collaboration and Dispute Resolution moved to admin from the Bureau of Mediation Services under admin's powers of reorganization. It's important to recognize that move statutorily. OCDR's valuable work fits well with admin's central service model for its services and the related work that we do, and we would ask for inclusion for that. While we are open to asking users of electric vehicle charging stations to cover the cost of electricity, we do not need to charge for the depreciation of the equipment as it's already been paid for in full. And finally, admin appreciates the chair's recommendations on selling the 1415 building and reinstalling the Columbus statue, but in both cases, there are already reviews underway by the CAT board as well as MDH on next steps for those issues and dispositions. Again, I thank you for your consideration and look forward to working with you throughout the process on this committee bill. Thank you.
Thank you. Next, we'll go to Commissioner Doty with the Department of Revenue.
Thank you.
Commissioner, just please state your name and go ahead with your testimony.
Thank you, Mr. Chair, for having me today. For the record, my name is Robert Doty, Commissioner at the Department of Revenue. I'm here to express the department's concerns about how Senate File 1831 will impact Minnesota taxpayers. As you know, the IRS in Minnesota opened the 2021 individual income tax filing season on February 12th. As previously announced, the Department of Revenue is extending a grace period to Minnesota taxpayers who will now have the opportunity to file and pay their taxes penalty and interest-free until May 17th. As of Monday, the department had received about 1.5 million individual income tax returns, processed nearly 1.4 million returns, and sent out about 971,000 refunds. The department works year-round to provide a variety of services to customers around the state. As drafted, this bill reduces the department's current general fund appropriation by $16.5 million over the biennium. This is approximately a 5% cut to our base. This reduction will negatively affect our ability to maintain the current levels of service we provide to Minnesotans. We will reduce the amount of money the department collects to fund vital state government programs. It will also impact the department's ability to maintain required support for technology systems to effectively process and protect private taxpayer data. This cut to revenue will have a directly negative impact on Minnesotans. Our resources fund our customer outreach and education and the tax administration system. The department cannot absorb the appropriation reduction and needs an operating increase to maintain our current service levels. The reduction in funds equates to reduction in staffing of about 90 employees. This would negatively impact our ability to administer the state tax system. This is not a situation where the department would be able to do more with less. There would be significant consequences for customers if this reduction is enacted. Customers will wait longer for refunds. Minnesotans will have a harder time reaching someone in the department by phone or email to have their questions answered. We will not be able to update information on our websites as quickly and will publish fewer revenue notices and revenue analysis. The department will have fewer audits and enforcement activities that address patterns of noncompliance. The department would have to reduce its existing investments in strong and efficient technology and cybersecurity systems. While we are continuing to examine the bill to evaluate all of its impacts on the department, I'm going to highlight one of the specific concerns we have already identified with this bill. We have concerns about the appropriation for taxpayer assistance. The governor's supplemental budget expanded this program with additional grants and funding for capacity building. We have heard how difficult it is to start a VITA site and want to be a resource to our partners in every corner of the state. We are eager to serve Minnesota taxpayers as efficiently and effectively as possible. To do so, we need your help to secure the appropriate level of financial resources and eliminate restrictions that may negatively affect our ability to protect taxpayer data. Mr. Chair and members of the committee, thank you for letting me speak to you today, and I'm happy to take any questions if necessary.
Well, thank you, Commissioner. We don't have any time for questions today, but they can follow up with you later on. So next we'll go to Ms. Coleman with the MPCA. Ms. Coleman, please state your name and continue with your testimony.
Yes, thank you, Mr. Chair and members. My name is Jean Coleman, and I'm a senior attorney with the Minnesota Pollution Control Agency. Thank you for the opportunity to testify on the amendment to Senate File 1831. My comments are directed at Article 2, Sections 14, 15, and 78, which relate to rulemaking, and Section 16, which relates to contested case hearings. The MPCA, Minnesota Pollution Control Agency, opposes these sections of the amendment. Sections 14, 15, and 78 deal with rulemaking. Through the Minnesota Administrative Procedures Act, the legislature created a process specifically designed to be transparent and involve the public. The general rulemaking process takes MPCA a minimum of 18 months and has many points at which the public can get involved. Public participation has been high in recent MPCA rulemakings. More than 5,000 Minnesotans gave input to our wild rice rulemaking in 2017, and more than 10,000 Minnesotans recently weighed in on our current clean cars rulemaking. Agencies are required to respond to all the comments, and we do. Our responses are posted on our website for complete transparency. Rules benefit those who are regulated. Because rules interpret broad statutes and provide specificity, those who are regulated know what is expected of them. If agencies are prevented from adopting rules, then agencies will be forced to evaluate situations on a case-by-case basis. This will take much longer, thus causing delays in services to regulated entities. The MPCA is delegated to implement many federal environmental laws in Minnesota. Federal requirements often have strict deadlines associated with them, which may be impacted by the provisions of these sections. And the failure to meet those federal deadlines can mean that the federal government takes over state programs. For all these reasons, we oppose sections 14, 15, and 78. Section 16, which MPCA also opposes, relates to contested case hearings. It requires all agencies, not just MPCA, to hold a contested case hearing whether or not the person requesting the hearing has submitted evidence contradicting the agency's proposed decision. The change would apply to all contested case hearing processes, including hearings on permits, rules, and enforcement of violations. The amendment removes all agency discretion and will result in many, many more hearings than currently is the case. This will make for delays in MPCA permitting, enforcement, and other processes. The cost in time and money of these required hearings will be high. Section 16 also places an administrative law judge in the position of making final agency decisions, thus removing the commissioner's authority. Administrative law judges, by definition, focus on administrative procedures, not agency operations and management. Therefore, most administrative law judges are not experts in agency statutory requirements and obligations, practices, history, operations, or management, nor expert in federal law. Agency commissioners are supported by experts in all areas of agency work, and so are much better suited to make final decisions. Due to the delays and costs of these provisions and due to potential conflict with federal deadlines or statutes, the MPCA opposes these sections. Thank you for the opportunity to testify today.
Thank you, Ms. Coleman. And next we'll go to Commissioner Thomas with the minute. Commissioner, please state your name and continue with your testimony. Thank you.
Good morning, Mr. Chair, Madam Chair, committee members. I hope my audio is okay. You can hear me okay. My name for the record is Tarek Tomes. I'm the Chief Information Officer for the state of Minnesota and the Commissioner of Minnesota IT Services. Thank you for the opportunity to testify today on Senate File 1831. While it's good to see that this bill recognizes the importance of implementing Blue Ribbon Council recommendations and continued investment in cybersecurity, it is important for me to note that this is an overall funding reduction that will negatively impact Minute's ability to perform its important IT leadership and cybersecurity role for the state. Over this past year, governments and organizations across the world have been tested by an unprecedented pandemic that has pushed the limits of technology. And here in Minnesota, technology has performed a central role in enabling the state of Minnesota's pandemic response and economic recovery efforts. This has been possible because of the close collaboration between Minute, our state agency partners, and the work with our partners in the private sector such as members of the Blue Ribbon Council on IT. The BRC is now looking for Minute to harness that spirit of rapid innovation and play a strong leadership role in technology services across state government, driving transformation and modernization. This bill, rather than providing funding to do that, cuts that investment and our ability to move government in the right direction. A fully funded investment would significantly advance digital services for Minnesotans that Minute promotes and supports alongside our state agency partners. We know the demand for technology will only increase. First, as we embrace new ways of working, government organizations must continue to leverage technology to enhance productivity and collaboration and promote a healthy work environment. Secondly, there will be a higher demand to meet Minnesota's needs in an increasingly digital world. This remote hearing is a great example of that evolution. We'll continue to see this shift across state government and have seen many examples, including the ability for Minnesotans to renew a driver's license online for the first time in Minnesota history, new ways to engage with Minnesotans with critical food assistance through services such as text messaging. Just last week, we passed 1 million text messages sent through the PEBT program, and our nation-leading efforts in the unemployment insurance space, making sure people have access to rapidly evolving federal benefits as quickly as possible in the midst of unprecedented demand. Third, investing in technology can change outcomes for people, particularly in the midst of a crisis. Technology allows us to reimagine service delivery and gain new insights that help us reduce systemic bias that individuals or manual processes may hold, and it creates the ability to effectively measure our success. We appreciate the inclusion in this bill of minute statutory cleanup provisions, as well as the changes that make the BRCIT the permanent advisory body for technology services in Minnesota. Over the past year, businesses, governments, and citizens have relied on technology as a connector and an enabler back to our normal lives. Many companies are doubling down on their investments in IT systems and digitization of services to be able to meet those demands and to provide better value. The state of Minnesota saw that same demand and will continue to see unprecedented demand for technology. We urge you to reconsider the funding reductions for state technology included in this bill. Like many public and private organizations across the world, Minnesota government has seen how critical and essential investments in digital capabilities truly are. As we emerge from this pandemic, digital capabilities that meet the needs and, most importantly, the expectations of Minnesotans should no longer be optional. Thank you to the bill author and committee members for your time today, and I look forward to working with you in continued partnership. I'm happy to answer any questions if there are any.
Thank you, Commissioner Thoms. Next, we'll go to Mr. Whitworth with the Historical Society. Mr. Whitworth, please continue with your testimony and state your name for the record.
Thank you, Mr. Chair. For the record, my name is Kent Whitworth. I serve as the Director and CEO of the Minnesota Historical Society, and I appreciate the opportunity to testify this morning. I'd like to comment specifically on sections 55 and 56 of Senate File 1831. These sections would remove operations of state-owned historic sites from the Minnesota Historical Society, and we are opposed to these provisions. Mr. Chair, the Minnesota Historical Society has successfully operated this network of historic sites for the education and enjoyment of Minnesotans and visitors to Minnesota for more than 50 years. These sites range from Split Rock Lighthouse to the Lindbergh House, to historic Fort Snelling to historic Forestville, and many more in between. We have diligently cared for 150 structures at these historic properties, and we've welcomed millions of visitors, school children, families, tourists, all seeking to learn more about our history. Now, this history is often complex, and we work to share the history in a fair and thoughtful manner. We frankly are mystified by why this proposal is coming forward at this time. We have not seen a bill on this concept, nor heard any discussion on why this is an issue. If there are issues with how historic sites are operated, we're more than happy to discuss those concerns and would invite you and other committee members to visit historic sites to see how they are operated. Further, this proposal would be confusing to the visiting public with two different organizations running historic sites under different systems. Mr. Chair, we respectfully request that the committee not move forward with the proposal to remove state-owned historic sites from the operations of the Minnesota Historical Society. Thank you.
Thank you, Mr. Whitworth. And next we'll go to Josh Downham with Minnesota Public Schools. Are you on? There you are. If you could please state your name and continue with your testimony.
Thank you, Mr. Chair. My name is Josh Downham. I'm with the Minneapolis Public Schools, and I'll be very brief. Today, I'm testifying in opposition to Article 2, Section 72, which reduces the state's commitment to the Minneapolis Employee Retirement Fund. And today I'm joined in opposition to this provision by Hennepin County, the City of Minneapolis, and the Minneapolis Park and Recreation Board. So, Mr. Chair, Section 72 would shift $10 million annually from state aid to local property taxes, increasing business and homeowner taxes for the next 10 years, nearly $100 million during that period of time. As the state attempts to help businesses and individuals recover from the pandemic, raising property taxes, particularly when the state has a surplus, is troubling. Over the term of this provision, for example, property taxes in Hennepin County will increase more than $3 million. The state and local units of government have had a shared stake in the success and viability of this fund since the state closed it in the late 1970s. That has continued up till today. And the current bipartisan deal that was reached in 2015 with local units of government covering 21 million and the state 16 million should be honored. And we're hopeful or would request respectfully that this provision be removed and that we not shift the burden on the local property taxes. Thank you, Mr. Chair.
Thank you, Mr. Downham. And next we'll go to Ms. Garlitz with the DNR. Ms. Garlitz, please state your name and continue with your testimony.
Thank you, Mr. Chair and committee members. My name is Annalie Garlitz. I'm the Government Relations Supervisor for the Department of Natural Resources. I would like to share the department's concerns with this use of the term specific, which is found in Article 2, Section 14. DNR has testified in committee when the original bill was heard, so my comments here will be brief. The term specific is not defined in statute, and as such, it's left to interpretation as to what is meant by specific and what counts as specific enough. This can cause an issue when any agency is granted rulemaking authority by statute, but that underlying statute does so using relatively broad or non-specific language. I can give you an example of how this might play out. There is a statute in Game and Fish Laws, 94B.605, that grants the DNR the authority to set open seasons and prescribe restrictions on taking of small game animals. That's all the authorizing statute says. Relying on that authority, DNR promulgated various rules for each specific small game animal, which is in Minnesota Rules, Chapter 6234. And in there's a specific rule for grouse, pheasants, partridge, jackrabbits, squirrels, and those are just some examples of some of the small game. Each of those rules has specific restrictions relating to that particular animal, but they're all authorized by general, non-specific language in statute. If it's determined that the underlying statute is not specific enough, then before DNR could amend the rules to set a new season or to impose a new restriction, DNR would first need to get specific legislation for grouse, pheasant, rabbits, squirrels, etc. So you can see how this would cause issues for very time-sensitive rule amendments when they're needed to adopt restrictions based on the previous year's harvest data that comes in. To sum it up, DNR concerns are with the term specific and what the term means and what effect that term has on the rules, where the underlying statute is written in more general or non-specific terms. Thank you, Mr. Chair and members of the committee, for your time.
Thank you, Ms. Garlitz. And now we'll go to Mr. Bruce from MAPE. Mr. Bruce, please state your name for the record and continue with your testimony.
Thank you, Mr. Chair. And can you hear me all right? All right. My name is Devin Bruce. I'm the Public Affairs Coordinator for the Minnesota Association of Professional Employees, a union of over 15,000 state workers across all agencies, boards, and commissions. MAPE strongly opposes Senate File 1831 as amended. This bill proposes to decimate state government operations and lay off hundreds of workers throughout the state. By not providing basic operating adjustments to maintain their current level of staff and functioning, agencies will not be able to provide operating adjustments to maintain their current level of staff and quality services that many of us utilize. Furthermore, the massive cuts to base operating budgets like the $14.6 million to the Department of Revenue will not create any efficiencies, only longer waiting periods and delays in services to businesses and Minnesota's taxpayers who must navigate the ever-changing labyrinth of state tax policy. The same is true for all of the other agencies in this bill. From a glance at the spreadsheet, only the Senate and the LCC are receiving an operating adjustment or experiencing inflationary costs to receive it. Beyond the austerity budgeting and the plethora of election changes, the policy proposals are equally objectionable. Article 2, Section 18 purports to change the process for layoffs by requiring an economic geographic distribution. This is a clear violation of rights guaranteed to us under PELRA and our contract to negotiate the terms and conditions of employment, including bumping, bidding, and layoff rights. Our union never likes to see people lose their jobs, and under this bill, it seems like many will in your communities. But this process is governed by the contract between our employees and the employer, which is the state of Minnesota. Section 20 is a limit on state employment growth based on population growth is an interesting proposition, but it doesn't take into the reality that the two percentages aren't linked together, and it's a rather simplistic approach to a complex set of problems in our dynamic ecosystem of state services. Section 66 limit on compensation interferes with our ability to negotiate in good faith with our employer over compensation. The bargaining units and MMB negotiate salaries and health insurance cost sharing based on the appropriations that are given by the legislature and signed into law by the governor, and can wildly fluctuate over time, particularly health insurance, between a tentative agreement being reached and open enrollment beginning. This provision would also interfere with agencies' ability to hire employees at competitive rates in places like DOC, where staffing levels are critical to safety. Section 77's base appropriation and FTE reduction after posted position is unfilled for 180 days fails to acknowledge that many of these are hard to fill positions or ones with high turnover rates, such as a therapeutic and psychology staff positions at the Security Hospital and Sex Offender Program in St. Peter, or where private sector salaries greatly exceed that of state employees such as IT. By eliminating open positions, you also eliminate the ability of state agencies to compete for the best workforce. For these and many other reasons, we ask that you oppose Senate File 1831 as amended, and I appreciate your time, and thank you, Mr. Chair.
Thank you, Mr. Bruce. And next and last, we have Commissioner Showalter from MMB. Commissioner Showalter, please state your name for the
Thank you. Thank you, Mr. Chair. Just getting myself on. I appreciate it, Mr. Chair, members of the committee. My name is Jim Showalter, and I'm Commissioner of Minnesota Management and Budget. Thank you for the opportunity to provide and comment on the Senate State Government Omnibus Bill. Minnesota Management and Budget, as you know, serves all Minnesotans by working to ensure state government is effective and fair, transparent, innovative, and always striving to improve. And we're pleased to see that several initiatives that we propose are included in this bill, including the Payment Plus program. Example of a way where we're able to look constantly for ways to innovate and create savings that benefit the general fund. Additionally, the bill provides MMB the ability to ensure that we have the ability to continue doing the single audit and ensure that we continue receiving federal funds. However, there are many aspects of the bill that compromise the ability of the department and other agencies to meet the needs of Minnesotans. Our concern is just reducing agency budgets. As you know, these budgets are what empower the executive branch to provide critical services to Minnesotans in accordance to the laws that are passed by the legislature. Rather than asking MMB to build on innovative ideas like Payment Plus, this bill reduces overall resources by 7.8% and adds on new responsibilities with uncertain results. Let me just provide real quick in detail about how these cuts impact MMB. As you know, state agencies provide critical services for Minnesotans. At MMB alone, we're responsible for more than 1,800 statutory requirements, coordinating the budget, the forecast processes, maintaining human resources and bargaining functions, managing $8 billion in debt, paying thousands of vendors, and other things. This said, we're looking for a 7.8% reduction in these really core services that affect all of the work of the state government. In addition, this bill reduces the number of executive budget officers by 6 FTEs. This cuts one of the best values in state government, where these are professional, flexible people who are integral to the internal controls and the infrastructure of the state. They ensure appropriations are established, spent according to law, provide technical assistance, work with the legislature in crafting and implementing these proposals. Diminishing this cohort is really going to have a outsized impact on the state. These reductions affect Minnesotans and our ability to really respond to whatever challenges come up in the next 2 years. For federal funds, this bill produces a new approach for how we review select federal funds related to COVID. It strips away the longstanding direction to maximize federal funds and replaces it with a requirement for a direct appropriation for these new grants. This is a significant policy change. And just note that the state already gets less from the federal government than other states. It limits the governor's authority to receive and spend federal grants in the interim, and it creates a hard to resolve debate about what bills are COVID related and what ones aren't. We know federal funds will be coming throughout the course of the year. The potential result is just an expansion of the legislative calendar and votes for direct appropriations that normally would have been handled through routine consultations in the LAC process. Finally, I want to say that there's an overly prescriptive management of state employees. Throughout Minnesota, state government services exist to ensure the needs of our citizens are met, whether it's ensuring our roads and bridges are safe, that we have access to vital services, support for learning in our schools and colleges and universities. These aren't easy tasks. And this bill creates multiple new constraints for agency heads to manage budgets and the people that power the results. We need to have adequate state workforce to address unprecedented times. We've seen that through the pandemic period where state employees developed grant programs for small businesses, established testing and vaccination sites, all while continuing the core functions of state government. Many of these activities would not have worked with the kinds of constraints that are in this bill. Arbitrarily linking workforce numbers with the state's population, the location of their work, the ability to hold off vacancies to adjust for other costs is just contrary to the notion of flexibility. That said, Madam Chair, Mr. Chair, thank you for the opportunity to testify today. I'll be following up with a letter to you and the committee that provides additional details on our concerns, but know that despite concerns, we look forward to working with you in the coming weeks to develop a bill that meets our shared objective, which is serving the people of Minnesota. Appreciate the chance to testify. Thank you.
Thank you, Commissioner. And with that, I'll pass the gavel back to Senator Kiffmeyer. Senator Kiffmeyer, you have the gavel.
Thank you very much, Senator Howe. Appreciate that. So members, we've concluded our work for today. Tomorrow we will also have our regular meeting time, and the intention is at that time we will have discussion, and also at the conclusion of that we will proceed to a vote on this bill and move it forward. So with that, members, our work being done for today, I'll see you tomorrow, and we are adjourned.